Friday of the month. And on this first Friday, our webinar is dedicated to the recent regulatory and legal updates in corporate securities and insolvency law during the month. So on behalf of corporate professionals and on my own behalf, I extend a very warm welcome to our webinar on legal updates today. It is indeed an honor for me to have you all here today to discuss the latest updates and regulatory changes in the field of company, securities, and insolvency law. We all know that all these three laws are crucial for the smooth functioning of the corporates as well as the economy. We also know that the legal landscape, as far as these three laws are concerned, is ever changing. And it is therefore imperative for all of us, the professionals in this field, to keep up to date with the latest developments and regulatory changes. Our panel today comprises specialists, experts who will share their insights and experiences on the latest legal updates and regulatory changes in these areas. They will also discuss the impact of these changes on the corporates as well as the economy. It gives me great pleasure to welcome the galaxy of our speakers today. We have with us Shri G.P. Madan, who is founder Madan Law Offices. He is also co-chairman SOCHM M&A Task Force. Mr. Manoj Kumar is partner and head M&A and Transactions Corporate Professionals. Nitesh Latwal is associate partner, Corporate Affairs and Compliances in Corporate Professionals. Mr. Ravi Prakash is associate partner, Securities Law and Corporate Litigation, Corporate Professionals. Neeti Mangala is manager, Capital Market Services, Corporate Professionals. And finally, we have Ms. Devashri Das, senior associate corporate professionals. I'm sure this webinar will provide a valuable platform for learning and discussion. And I hope that it will help all of us to gain a better understanding of the recent regulatory and legal updates in the field of company, securities, and insolvency law. We will begin with the company law updates. And I now invite Mr. Nitesh Latwal to take us through the updates in company law. Over to you, Nitesh.
Thank you, sir. Good evening, friends. Let's start with the last month amendment which came under Companies Act. So there's not much update, but there's a very crucial update in the side of the corporates. The Ministry of Corporate Affairs has established a separate section for dealing with the striking of matters. So we have incorporation, we have a separate center for dealing with the incorporation, because incorporation being a very integral part. First, because whenever a person thinks about establishing a business or setting up a business, the first start is to incorporate a company. But at the same time, there are many businesses which fails. So there are many reports, it's domestic, internationally, where India is not at a very good position when it comes to liquidation or winding up or striking of the company. So on the same line, and considering that it should take the pace of dealing with striking of the company in a time frame, or in a time frame as early as possible, so that the directors and the stakeholders involved in that company get relieved. So on this line, the Ministry of Corporate Affairs has established one center which is called CPACE. It stands for Center for Processing Accelerated Corporate Exit. So it will be deemed to be a registrar of company when it comes to filing the application. So all the matters with respect to dealing with processing of striking of application, it has to be dealt with by that center. Okay, so the application is STK2, which is dealt by this separate registrar. So it is pertinent to note that it is only dealing with the application. It will not, it does not have the jurisdiction to penalize the company, to issue show cause notice for not filing the annual return or balance sheet for more than 2 years, which under section 248 is where the registrar of companies has the power to issue the notice to defaulter whosoever is not filing the annual return or balance sheet for more than 2 years. So that jurisdiction does not fall under does not fall in this new registrar will not entertain, will not have this kind of jurisdiction. It only has the jurisdiction to deal with the application of striking or application. So subsequent to that, there's a amendment in the rule of striking off. The rule is rule number 3 has been amended, specifically sub rule 1. The sub rule 1, earlier there is a provision that if the company is not functioning and is also has not filed annual return and balance sheet, then they are exempted for not filing the annual return or balance sheet for those years in which it did not carry out its business operation. Then in the amended rules, that has been done away with. I think that is a good step if we talk about this, because earlier, because the old rule is something suggesting that it gives you a privilege, or it gives you a free hand not to file the balance sheet or not to file the annual return till you carry out the business. I think this is a bad message which was going to the stakeholders. I don't think, because it is against the intention of the legislature. I think that has been corrected now. So if you are if today, as per the new rule, if you are filing the application of striking off, then you need to file all those returns and balance sheet for which you since incorporation, even if you have not carried out your business. There's one more change in the form, not in the rules. There you need not to attach special resolution, because MGT for the challan, the SRN of challan of MGT 14 you need to insert. No need to no need to file especially the special resolution in the strike off application. There's a landmark judgment which recently decided by the Supreme Court. It is the application, the appeal filed by the Union of India against the order of the Bombay High Court in the matter of former auditors of ILFS Group. So it is with respect to debarment of the auditor. Debarment of the auditor for 5 years, where the High Court hold that the that the legislature intent is to induce or effect a change of an auditor in a company where there is a suspect fraud. The intention of the 140 subsection 5 is to break the collusion between the auditor and the company. So the auditor of the council representing the auditor contended that 140 subsection 5 does not arise once the auditor resign from the company. They also contended that it violates my fundamental rights because on the ground that there is a different treatment of defaulting directors and the auditors for the same kind of offense, and banning the audit firm for 5 years affect their livelihood. However, the Supreme Court has turned down their contention and overruled the judgment of Bombay High Court. The Supreme Court upheld that the auditors act in a larger public interest and for all the stakeholders, because on the basis of their report, whether it is a qualified report or unqualified report, their report actually influence the decisions of the other parties whether to have dealing with that company or not, because their report suggests that whether the company their report suggests that it is giving the financial result which is prepared by the management is giving true and fair picture of the business of the company. If their independence is in any way affected, then it is not good for the people at large, for the public at large. And the section 140 subsection 5 was inserted to make the provision more stringent and to provide for a consequence for an auditor when such auditor is found to have involved in a fraud with the management. If subsequent to the resignation or continuation of auditor shall not terminate the proceeding under subsection 5 or 40 of the Act, otherwise it will pave the way for an auditor to rescue itself from the proceedings, which cannot be the intention of the legislature even on resignation. Because if the contention of the auditor is accepted, then every auditor will get away from this the consequence of this section, which is banning for the 5 years and fraud. Because this way is never the intention of the legislature. If you resign, you get away with this provision. This is not the intention of the lawmakers. Therefore, the Supreme Court said that the penalty for debarment of 5 years cannot be said to be violative of Article 19(1)(g) of the Constitution of India. So they held that 140 subsection 5 is equally applicable to all the auditors, even if they resigned. That's it, sir, from my side.
Thank you very much, Nitesh. In fact, the amendment in the striking of regulations is in continuation of the statement made by our Honorable Finance Minister during the budget speech. And to my mind, the two advantages. One is that we have a dedicated registrar to attend to these applications. So he can concentrate on this, and the pace of striking off the names of the companies would be accelerated. And at the same time, the jurisdictional ROCs will be freed from this particular work, and they will have more time to devote to their other work. Thank you very much, Nitesh, for updating us. Now, I request Debashri to take us through the updates in as far as the FEMA regulations are concerned.
Thank you, sir. Good evening, everyone. So we have a couple of updates with regard to NBFC RBI compliances in the last month. The first one was related to the simplification of core investment companies registration process, which the RBI came up with last month. So as per the press release, the process of registering a CIC, which is, as we all know, there is one unregistered CIC and there's one registered CIC. For with regard to the registered CICs, the process for registration has been simplified. Earlier, there were around 52 odd documents which were required to be given. Now, with the revised application process, the application process as well as the annexures have been completely overhauled. And now, as opposed to 52 documents which were supposed to be given earlier, only 18 documents are to be given. A detailed analysis of the comparison of the earlier set of documents and now the current one states that although the number of documents have apparently reduced, but the content has not reduced much, to say that couple of annexures have been made a part of the revised application process, and few of them have been incorporated in the application process, and that is the result. The number of annexures have apparently reduced. And also, the earlier application had reference of the 2011 master circular, which was there for CICs. The current regulations, the current application has reference to the latest master directions for CICs, which were issued in 2016, and of course has reference to the latest scale-based regulations. Quickly, couple of points which have been actually reduced or removed from the application completely. And one major change that has added to this is that earlier memorandum and articles of association details, I mean, the entire set had to be submitted. Now that has been done away with, it has been removed. As of now, only the certified clause which states that the company can undertake such and such activities, only that needs to be given. The entire MOA need not be submitted now. Further, there was a requirement of submitting a board resolution for formulating the fair practice code, which the probable CIC had to submit earlier. Now that has been removed. So which means that now the onus, or rather the process of implementing a fair practice code, would of course be done once the registration is obtained, and post that, as part of, along with other policies, the company will have to prepare this. But the requirement of passing a board resolution earlier and submitting the same is not required now. Further, in case of startup companies, there was a provision, there was a requirement that they had to share the source of the startup capital. Now that is not required. Of course, the source of capital somewhere is indirectly covered, but specific requirement of this has been done away with. Another one major last change that we have observed is that earlier the annexure 1, which had details of the company, all the details of the company which was undergoing the registration, that was certified only by the directors. Now that annexure has to be certified by the statutory auditors. And so accordingly, this is probably, as we understand, is to harmonize it with the existing RBI, with the existing application that goes for other NBFCs in general. And this is one major thing that which we have analyzed in terms of the certification. So earlier the onus or the this is to say just another level of we can say the certification that RBI is taking from a statutory auditor in terms of details that are contained in Annexure 1, which primarily contains all the details of the companies, the past activities, and financial numbers and everything. Of course, this list is not exhaustive. it is indicative, and during the process, RBI can also ask for other additional documents as well. So this was it with regard to the simplification process. Moving to the next. Another major change that happened during the last month was the master direction that came out with regard to the outsourcing of IT services. So as we all know that information technology is the backbone of the financial services industry, the NBFCs and the fintechs primarily. And nowadays, outsourcing has become a general day-to-day activity, wherein some of the other activity is being outsourced by the NBFCs, fintechs, and a lot of parties are per se involved in this entire process. And this has always been a pain area for RBI when it came to identifying the main parties involved and fixing the onus or the liability or the responsibility of ensuring the governance. So accordingly, in 2017, we had master directions for IT framework, which primarily spoke about the provisions that had to be contained in the agreement between the NBFC and the IT service provider. And it also outlined the role of IT strategy committee, which was very much elaborated earlier. Now with these new directions, which were initially last year in April 22, they were issued in the form of draft guidelines, which were open for public comments. Now in April this year, on 10th April 23, the final master directions have been issued, which becomes effective from 1st October 2023. Ample time, around 5-6 months time, has been given because of certain provisions that we'll be studying, that we'll be having a look in the subsequent slides. This will be applicable on the NBFCs in the middle layer and the above layer and above, which is the middle layer, upper layer, and top layer. On payments bank, on small finance banks, on scheduled commercial banks, on CICs and alternate investment funds, and all India financial institutions. Two key definitions have been added. One is the services which are to be considered as outsourcing, and services which are not considered as outsourcing have been added. And entities which are not considered as third-party service providers has been clearly defined now. Earlier, there used to be a confusion in terms of the services and the parties that are involved, as in a IT infrastructure, lot of entities and lot of services which were ancillary to the original, to the main activity, were also there. And it was at times difficult to identify who would be taking care, who would actually be responsible to ensure the compliances. So now with these master directions, the services and the entities have been clearly spelled out. In terms of, going to the next slide. These are certain services that are considered as outsourcing, which is IT infrastructure, of course. Development of apps has been considered as a service. Cloud computing services, which is essentially probably the backbone, or as we may call the the skeletal of the an IT infrastructure, that is also service now. Management of IT infrastructure and technology services associated with payment system, that is also being added in the definition of the services. Further, services, vendors, and entities that are not considered as outsourcing, or the entities which are not to be considered as third-party service providers. This includes SMS gateways, applications provided by financial regulators, business correspondents, vendors who are providing business services, let's say the business correspondents primarily, the payment system operators, since they are already authorized by RBI and they have their own set of regulations. So they have been removed from the purview of this for now. And of course, services of fintechs, which includes bank statement analysis, GST return analysis, digital document execution. These services have been removed from the purview of these outsourcing guidelines. Next, so IT policy. If before moving to this IT policy, maybe I'll quickly share the details, the broad structure of the master direction that has come. It primarily includes the role of the entity, the governance framework that it has to establish, the process of evaluation of the service providers. Of course, every company has its own reasons to outsource or onboard a particular vendor, but these policies, this master direction clearly spells out that uh, complete detailed due diligence has to be taken of the service providers, of all the eligible service providers, and different aspects, qualitative, quantitative, operational, legal, and reputational factors. All these factors need to be ensured, need to be taken into consideration before finalizing one vendor for outsourcing. Further, it also talks about risk management, monitoring, control of the outsourced activities, wherein instances where a service provider, let's say, is acting as an outsourcing agent for multiple companies or for multiple, say, banks or NBFCs or payment service providers, care should be taken to build adequate safeguards so that there is no combining of information amongst with that particular service, with that particular vendor. Regular audits should be conducted. Then, of course, outsourcing, if there is outsourcing within a group, it should be ensured that, and if there is cross-border outsourcing as well, it should be ensured that government policies of that jurisdiction are being monitored. And it should also be ensured that the entity which is outsourcing and RBI, they should have the right to conduct audits in that jurisdiction. It should not so happen that a certain jurisdiction where the service provider resides, type is being done, and then the NBFC, let's say, or RBI, in fact, is unable to gather information or take back the information or execute certain parts or certain specific clauses of the agreement. So that needs to be ensured. Then, of course, exit strategy is one thing that has to be there, which would clearly outline the business continuity, how a particular process will flow before and after the vendor takes an exit. Then how data and information should be removed, or how the service provider should not be allowed to tamper or make any modifications or erase the data that has been with the service providers servers, or in whatever way it has been saved. Preparing an IT policy is probably one of the first steps that the entities will have to ensure with these master directions. So accordingly, a couple of points have been highlighted. One, the roles and responsibilities of the boards and the committees need to be clearly ascertained. Then, as stated earlier, the criteria for selecting a particular activity and its corresponding service provider also needs to be ascertained. And there should be proper guidelines or proper policies behind this. Outsourcing to any group or outsourcing within the group, of course, also needs to be highlighted. And reasons for outsourcing within a group also needs to be taken into consideration before finalizing a vendor. Exit strategy also needs to be there. Cloud adoption policy, one major addition to this master direction, since cloud-based services are increasing, and as said earlier, they are the backbone. So cloud adoption policy should cover the entire life cycle of the data, identification of the activities, how the data moves from cloud, who are the stakeholders involved, how their interests, their diversified interests need to be safeguarded. All these things need to be ensured. Then moving to the next aspect, other key points apart from the IT policy, which of course would be the first step towards implementing this master direction. Another key points should be that in case where there is a service provider who is not a part of the group company, then that service provider should not be owned or controlled by any director or KMP of the regulated entity, which is the NBFCs or the parties to whom this master direction is applicable. Need for outsourcing the IT services should be evaluated. Inventory of services need to be maintained in a legible and clear manner, wherein the entire life cycle of how a data is moving, the entire process needs to be streamlined, and inventory needs to be maintained in terms of how much dependency that NBFC or an entity is having on the external party. and it should be mapped, it should be regularly evaluated. Then, of course, risk management framework, NBFCs and entities already have. They should incorporate the outsourcing of IT services in the existing risk management framework. Cyber incidents, earlier the time limit was much higher. It was around 24 hours, I believe. Now it has been reduced to 6 hours. So this has been introduced, one major change with the master directions, that immediately within 6 hours of detecting the a particular threat or an incident, it needs to be reported within to the RBI by the regulated entity, not by the service provider, not by the outsourced agency. And then, of course, in addition to the outsourcing of IT service controls, storage, computing, and other aspects also need to be taken care of. So these were certain couple of key points with regard to the information technology services outsourcing. Moving to the next. Another major amendment and the last that I'll be covering is the change in the master directions for KYC. KYC, as we all know, has always been one of the most technical or difficult rather aspects when it comes to implementing then execution and nitty-gritties of the entire process. And last month, in the month of March, the PMLA guidelines were changed. Notification came in the first week of March, and accordingly, the KYC directions have also been changed now. The purpose, of course, is one to bring it in line with the money laundering provisions, and then, of course, as now everything is going digital, the Payment and Settlement Systems Act, which takes care of the entire payment system, the account aggregators, the payment gateways, payment aggregators. Somewhere there was not a gap, but rather the process of maintaining, the process of undertaking the KYC has been made such, the master directions have been amended in such a way that those acts are also are in sync with the rest of the all, primarily the digital lending, the digital transactions to say. Couple of changes have been moving to the next slide. Couple of of course, there have been a lot of changes. We have tried to concise and compile them under different activities or different stages of a KYC process. The beneficial ownership limit has been reduced. Earlier, it was 25% for companies now and 15% for trust. Now, beneficial ownership will be determined at 10%. Of course, this would give a huge impact on the parties involved and the KYC and the owners of the, or rather the applicants, the number of applicants on which the KYC directions would apply. So, although these directions have to be ensured going forward, so accordingly, right from the date of the master directions, transactions being taken after that day, from the date of the master directions and henceforth, and this percentage will be reckoned accordingly. Another change in terms of the video customer identification process, wherein earlier it was mentioned that the in case of an offline verification of Aadhaar, wherein the XML file or the Aadhaar secure QR code was used, the time limit was given as 3 days. Now it has been specified into 3 working days. And also earlier it was mentioned that if in case there is any process, in case there is any disruption in the process, the video verification process needs to be started immediately, needs to be terminated, and a fresh session needed to be initiated. But now that there is a slight relaxation, it says that if it does not lead to any creation of multiple files or there is no major disruption, then the same can be continued. Next, another aspect in terms of the documentation, there have been changes which have been made in the KYC master directions. So it says that in case when the verification is done by downloading from the CKYCR, in case where the validity has lapsed, it should not be considered for KYC. So earlier there was no time period specified, and the REs or the entities used to look into this at the time of subsequent or the subsequent verification that used to happen on an ongoing basis. But now it has been specifically mentioned that when the validity has lapsed, the same cannot be used and fresh documents have to be submitted. A couple of additional documents that have to be taken in terms of a sole proprietorship, which is the Udyam registration certificate. Earlier, only the registration certificate was mentioned. Now it has been clearly spelled out that Udyam registration certificate needs to be considered. For company and partnership, of course, the name of the relevant people holding senior management positions, partners, registered office, principal place of business. These have been added to the existing list. For trust, the beneficiaries, trustees, settlers, and the list of trustees and the documents, all these need to be obtained mandatorily in addition to the existing ones. Moving to the next. A couple of additional things that have been outlined in this master direction. One, of course, is that the customers, the non-profit organizations, the definition of NPOs also have been slightly amended. So accordingly, it has been stated that the NPOs need to be registered on the Darpan portal of the Niti Aayog. And in case they haven't done so, then the entity, the RE, should ensure that it is done, or in fact, even help the entity to do so on their behalf. GST details, when available, they should be verified from the verification facility of the government. And any other information which is not there in the KYC policy, it can be obtained only with the explicit consent of the customer. Earlier, there was no such thing explicitly mentioned. And there were times when entities used to capture documents which were apart from the KYC policy, and then customers used to raise grievances in terms of the additional documents that have been given outside the policy. So now it has been mentioned that specific approval or consent needs to be there of the customer. Then the other aspect that has been modified, moving to the next, is the due diligence part. This provision has been added. It was not there earlier. Of course, it was at the discretion of the companies to do so, the banks and the NBFCs. But now it has been clearly spelled out that in case there is any suspicious money laundering or terrorist financing activity that the entity realizes, then the customer due diligence process should not be pursued further. And instead, the suspicious transaction report should be filed with the FIUND on immediate basis, and further due diligence should not be undertaken. Another thing which has been mentioned, of course, again, it was at the discretion of the companies earlier, that accounts which were opened using the Aadhaar OTP based eKYC in non-face-to-face mode, in those cases, the mobile number which is agreed, which is registered with Aadhaar only, needs to be ensured. This is one thing that has been clearly spelled out now, and any modification or any deviation from this should be undertaken by the regulated entity only as per the specific policies that they can make in this behalf. Up next, this one major thing has been introduced in this modification last month, which is the enhanced due diligence. So additional measures have been added when it comes to non-face-to-face customers. The reason can be said that now that all the customers, given the digital era we are in, and most of the companies, NBFCs, fintechs, are onboarding customers through digital mode only, and there is very less physical involvement that is there now. So additional measures have been introduced, which needs to be followed, which is in line with the existing norms, and these have been specifically outlined for the non-face-to-face customers. So it says that wherein the video customer identification process has been introduced, the company, the entity has to mandatorily let the customer know that such an option exists, and the customer should be given an option. The video verification should be the first option given, and then of course, if the customer is not comfortable or opts for offline verification, then that can be, of course, taken care of as per the policy that the company makes. Alternate mobile numbers, again, as stated earlier, should not be linked with the, once the due diligence process is done, again, any alternate mobile number should not be added for transactions or OTP and other information. Verification of current address should be undertaken through positive confirmation. Then first transaction should be credited from existing KYC compliant bank accounts of the customer. Earlier, it just stated that there should be the first transaction should be from a KYC compliant bank account, but now specifically it also got a credit. So there is a major shift in this, and NBFCs and companies will have to probably make an additional layer of transaction or an additional compliance when it comes to ensuring this particular thing. Customers should be categorized as high risk customers who are opening their accounts through non-face-to-face mode, and they shall be subjected to this enhanced monitoring until the identity is confirmed. So this is one major change that has happened. Moving to the next, another small changes that need to be ensured is one, it should be ensured that the mobile number of the Aadhaar for Aadhaar authentication is same as the one available with the company in the customer's profile. Any change, of course, as stated earlier, should follow a detailed due diligence process. Aadhaar OTP-based eKYC non-face-to-face mode can be used for periodic updation also. Earlier, it was not allowed for periodic updation. And one of the important things is to, in case there is any change in the existing documents, then within 30 days, the customer has the liability to inform it, has the liability to submit the revised documents or the updated documents to the company. And a declaration to this effect will have to be, it has to be undertaken by the customer that the customer will do this. And otherwise, the entire KYC process will have to be undertaken again. Next. Few changes specifically related to technology, where cloud deployment model is used, which nowadays most of the entities are using. The ownership should rest with the entity only. And earlier, there were certain obligations which were cast upon the other entities which were ensuring or helping the KYC or helping in the KYC or the identification process. But now it is completely, it has been, it vests with the RE only. And no data should be retained by the cloud service provider or third-party technology. REs may adopt artificial intelligence and machine learning techniques to support monitoring. Then, of course, money laundering and other risks should be identified, and they should be clearly spelled out when a new product is being introduced. And in fact, even for the existing products, earlier it was mentioned, but it was up to the REs at some point of time. It was up to the discretion given the size of the REs. But now it has been made mandatory that the terrorist counterfeiting and these money laundering activities have to be a part of the, have to be ensured, have to undergo a due diligence process at the time of new product initiation. Next, in terms of, with regard to policies, a group-wide policy has to be implemented for discharging the obligations under PMLA. Earlier, it was just a part of the KYC, not mandatory, but now it has been clearly spelled out that a group-wide policy needs to be implemented, wherein all the parties involved within the group on whom the application, on who are required to, who are somewhere connected or are contributing towards the KYC, all the activities, all the parties will be taken under the ambit. Risk categorization of customers earlier was also done. Now an additional clause has been, an additional aspect has been introduced, wherein it says that the geographical risk and the delivery channel, that is the way through which the credit is being given. These two aspects also need to be considered when it comes to risk categorization of customers. This probably holds significance now that all the channels, companies are generally using digital channels. And this is a contrast to the earlier regulations wherein there were physical verification, physical disbursements and account disbursements and offline verification of KYC used to happen. But now in terms of categorizing customers on the basis of risk, these transactions, these aspects also need to be considered. Then, of course, one last thing which has been clearly spelled out is that the categorization in which the customer is being put into, it should not be disclosed to the customer. Then next. Certain other changes. One major change in terms of the agents, wherein the liability of the agents have been removed. So earlier, if we talk about the provisions that were existing, agents used for marketing of credit cards were also subject to due diligence and KYC measures. Persons authorized by the NBFCs for collecting the deposits, and they were also required to undertake the KYC guidelines. All the information should be made available to the RBI to verify the compliance with the KYC guidelines. This was one provision which was there earlier. It has been removed now. Also, one provision which has been deleted is, which used to read as, I quote, the information shall be made available to RBI to verify the compliance with the KYC guidelines and accept full consequences of any violation by the persons authorized by the NBFCs who are operating on their behalf. So earlier, entities who were, the outsourcing agents rather, or other entities who were told by the NBFCs, who were hired by the NBFCs, also had direct liability or onus to ensure the compliances. So that has been removed now. Another 2-3 couple of things. Know your employee or staff policy has to be maintained now, which has to be followed at the time of hiring. Then obligations under the security resolutions, a lot of other schedules have been introduced wherein compliance to these regulations need to be, with respect to the amendment that has recently happened, the KYC guidelines have been modified accordingly, and they have been added to the schedules to the KYC directions now. So that's it.
Thank you very much.
This was
You've beautifully taken us through the changes, which to my mind are very significant, very vast, and having a lot of implications. And thank you very much for your very simplified presentation of such a complex subject of KYC. Now we switch over to the changes. Some circulars have been issued under the securities laws. So I'll request Neeti Mangla, Manager Capital Market Services Corporate Professionals, to take us through these circulars. Neeti, please.
Thank you so much, sir. Good evening, everyone. Now moving on to the circulars issued under securities law. So SEBI is one such regulator which is quite very much proactive in identifying and analyzing the issues prevailing in securities market. And in every month, we have quite many circulars issued under this category. In the month of April as well, SEBI has addressed quite many issues. So we are going to discuss some of them, some eminent circulars which have been issued by SEBI. First is formulation of price band for the first day of trading pursuant to IPO, relisting, etc. in normal trading session. So this particular circular is issued by SEBI to the stock exchanges. This circulars form part of the internal regulations of the stock exchanges. It basically talks about the opening price once the security get listed, that is at the time of IPOs, and when securities after the reduction of share capital comes in, there's a relisting of securities, and also with regard to companies listed under Rule 19 2B mechanism. So what happens is that there is a concept called a call auction session or pre-open session. Earlier, what used to happen under this pre-open session, SEBI provides a particular window which opens prior to the trading hours, and under which the orders are placed by brokers. Orders for buy and sell are placed, and there's an order matching concept. The orders which are matched, are being used as the on the basis of the orders matched, equilibrium price is being determined and price band is calculated. And if suppose a security is listed on more than one stock exchange, suppose on NSE as well as on BSE. So this pre-open session or call option session will take place respectively at each of the stock exchanges, and order matching will be independently done by both of the stock exchanges, and there are chances that equilibrium price determined order matching concept and equilibrium price thereon is different at both of the stock exchanges. And then there will be a change in price band as well, which might lead to this, which might be misleading for the investors, that NSE, the price band is 5% and BSE price band is coming out to be 10%. So that might be misleading to the investors. So of late, SEBI has addressed this issue and has come out with the concept of common equilibrium price. Under this mechanism, SEBI has provided the mathematical formula to the stock exchanges to come out with the common price band, uniform price band. So under this, what will happen? Independent call auction pre-open session will be taking place at all these stock exchanges, and order matching will be done. Each of the stock exchanges will determine their equilibrium price, and prior to order matching, they will discuss the equilibrium price, and if there is a change in their equilibrium price at each of the stock exchange, then arithmetical formula is given to determine the common equilibrium price. Both the stock exchanges, this common equilibrium price will be the volume weighted of the equilibrium price determined at each of the stock exchanges. So they will be determining the common equilibrium price, on the basis of which common price band will be determined, and only unexecuted pending orders from that pre-open session within the aforesaid price band shall be carried forward to the normal market segment. So this will be effective for all the price discoveries, IPOs, relisting, reduction of share capital happening with effect from 11th June 2023. Earlier, these were governed by SEBI circular, which came out in 2012, I guess. Now, this issue has been well addressed by SEBI. Now, moving on to the next circular. Now, guidelines with respect to AIF. AIF has been quite sensitive topic to SEBI, and every month we are seeing many changes in AIF regulations. Since AIF regulation is quite evolving concept, and SEBI is continuously putting on restrictions and acting as a watchdog to these AIF schemes. Now, one such guideline which SEBI has issued with regard to excusing or excluding an investor for making a particular investment in AIF. Under AIF, the investors are required to put in funds into the scheme, and this particular clause with regard to excuse or exclusion is contained in the private placement memorandum. SEBI has also provided a template for PPM in which the AIF has to disclose with regard to events under which an investor can be excused or excluded from making a particular investment in the AIF. So what companies used to do, they used to keep it open-ended. And what we have also experienced, since we are also giving this service of AIF, we are acting as merchant bankers, the PPM which we have received, the fund managers used to put the clause that investors may be excused or excluded for such other reasons as may be deemed fit by the fund manager. So SEBI does not want to give such kind of discretion to the fund managers to excuse or exclude an investor. Also, even they don't want an investor to cherry picking any investment to be made by them. So SEBI has particularly specified the events which are required to be disclosed in the placement memorandum, which is to be filed at the time of registration with SEBI. So with regard to providing an excuse to investor from participating in particular investment. So excuse is particularly an act which is to be proved by the investor. Excuse and exclude are two different terms. Excuse is to be given as an allowance or forgive, or investor is to be forgiven, and exclude is at the part of the investment manager when the fund manager deems that investor has to be barred from making an investment. So two events SEBI has specified in which investor can be excused from making a particular investment, and under both these two events, the onus is on the investor to prove to avail this allowance of not to invest. One such condition is that if the investment to be made is in violation of applicable law or regulation, provided that investor has to obtain and provide the opinion of a legal professional and legal advisor confirming the same. Second is the situation if the investment to be made by the investor is in contravention to the internal policy of the investor. So under this point, the SEBI has also recognized the right of the investor. Also, it has taken care the interest of the fund as well, and it provides that investor has to provide within 15 days of any such change in policy, so that it is not left at the discretion of the investor whether to choose to make any investor and he malafidely make changes in its policy to not to invest. So any changes in internal policy of the investor has to be disclosed to AIF within 15 days of such change. So these are the two conditions in which investor can be excused from making a particular investment. The onus is on the investor is to provide the requisite documents. Now, moving on to the cases wherein AIF may exclude. In this exclusion, the decision making is with the AIF. So in this, SEBI also has also recognized the interest of the AIF that if any investment by the investor would result in material adverse impact on the scheme of AIF and other investors, then also AIF can exclude or bar that investor from participating in particular investment opportunity. Also, SEBI has made sure that it is not left, the same has not been left open-ended, and that is why it has specifically mentioned that fund manager shall record the rationale for such exclusion along with documents relied upon. Next is if the investor has one or two investment opportunity, then also fund manager may exclude, or investor can avail the excuse to not to invest in particular investment if investment rationale is same of both the funds in which he is an investor. For the same, the reasons has to be recorded in writing along with supporting documents. This is all for the excuse and exclusion clause. Both these clauses has to be specifically mentioned and set out in the private placement memorandum. Next is direct plans for scheme of AIF. This another circular issued by SEBI in which it has allowed direct plans of AIF and trail model distribution commission in AIF. In AIF model, what used to happen, the fund manager establishes a fund in which the fund manager appoints the distribution agencies or placement agents which can tap investors, and there are investors who invest in the fund which is being managed by the fund manager, and investors can suo moto invest or the placement agent can pitch them to invest. And these investors particularly have appointed certain intermediaries which suggest them whether to invest or not and which schemes are prevailing and in what to invest. That is this portfolio management, investment advisors. So what happens is that this investor is paying professional fees to those SEBI registered intermediaries, like portfolio management fees, investment advisory fees. And what used to happen, and he is making contribution in the scheme, means he's investing in the scheme. And what used to happen in the schemes, there's a specific clause that whatever contributions are being made out of those contributions, a cut will be given. There will be a commission, and which is a cost, which will be given to the placement agent. It's appointed by the fund manager. So currently, what used to happen, that there is a dual burden cost on the investors. He is paying to his advisor as well, and secondly, there is a cut from his contribution which he is making, which is being paid to the placement agents. And what SEBI has proposed, that investors can suo moto invest under direct plan. That is, if they have appointed any advisory or any portfolio management services and they are already paying fees to them, then they can directly invest in the funds, and there will be no further cut or no further placement fees will be deducted from their contribution. Under the current mechanism, this direct plan option is there, but it was optional, and this particular clause is to be disclosed in private placement memorandum. In AIF, private placement memorandum is the governing document. Whatever is mentioned in private placement memorandum, that is the Bible. So what we have observed from our experience, most of the funds, they have mentioned on a direct plan not applicable, means they are not opting out for this direct plan option. Now, SEBI has made mandatory to provide a mechanism for direct plan. Under this schemes, under this AIF schemes, now investors which have appointed intermediaries, they can directly invest in the AIF, and there will be no further deduction from the contribution made. Next is with regard to trail model for distribution commission. Now, under this trail model comes the scenario for the investors which are not covered under direct plan. This is for the investors which are apart other than direct plan. Under this model, what used to happen at the time of entering into the scheme by the investors, there is no fixed mechanism that how much distribution fees is to be paid upfront. That is being charged at the discretion of the fund manager. Some are charging quite high. And what used to happen, it is a cost for them. And even though fund is not liquidated, they have not got their enough returns, and they have to pay this cost. So what SEBI has suggested, SEBI has put out a trail model for distribution commission. This is being laid down as in the case of mutual funds. So category 1 and category 2 AIF. Category 1 AIF is for venture capital fund, startup fund, and category 2 funds are relating to private equity fund, debt funds, which are required to pay up to only 1/3 of their total distribution fees to the distributors on upfront basis, and remaining they have to pay every year. And for the third category, third AIFs, which particularly relates to this hybrid funds, which invest in complex structured instruments. And for those, there is no upfront distribution fees or placement fees is to be given by the investors, and they have to pay the same on equal trail basis. So this is again the welcome move for the investors, since they face liquidity issues in case of AIF. Though these are the changes which have been suggested by SEBI, but what we see in other jurisdiction, the lawmaker, since AIF is basically with regard to investment by sophisticated investors. So in other jurisdictions, the lawmaker is not so much restrictive and not so much stringent. So this might act as a restriction. This might appear as a restriction to the fund managers. And let's see how markets perceive it. It is a new provision for them as well. Now moving on to the introduction of issue summary document. SEBI in its circular dated February 15 have advised the stock exchanges to come out with the XBRL utility with regard to issue summary document. What happens is that whenever we come out with any issue, whenever this any letter of offer or any issue document is being issued, and that issue document is quite comprehensive, must be about 250, 200, 300 pages. And in case of private issues in which there is no comprehensive issue of issue paper available in public domain, the market participants come to know of this information through corporate announcements, which is generally scattered, and investors and other stakeholders has to collate all those announcements and to get a picture. So what SEBI has suggested, that stock exchanges have to come out with the XBRL utility, under which the main features of the corporate action or the scheme has to be laid out, and it will be displayed on the website of the exchanges and will be available to the various stakeholders for their decision making. With this XBRL utility has come out in phases. First phase is for public issue of specified securities for offer documents filed on or before March 1, 2023. In second phase, XBRL is to be filed for further issues like preferential issue, rights issue, QIP issue, issue of ADR, GDR, FCCB, has been already implemented with effect from April 3rd, 2023. And all these XBRL utility has to be filed at the time of in principle stage as well as at the time of listing stage. In the third phase, which has been recently become applicable, it has become applicable for open offers, buyback, voluntary delisting. So all the companies coming out with any of these action has to keep in mind that they download the XBRL utility from NSE, BSE or MSCI's website and duly file them in timely manner. These all are the major circulars issued by SEBI and stock exchanges in the month of April. The next, SEBI has come out with one exemption approval as well. And that exemption approval is with regard to exemption from takeover implications for acquisition under the rights issue. Under the rights issue, there is no exemption from Regulation 3(1) of SEBI takeover regulation. That is, any person, including promoter, along with PSE, cannot breach the threshold of 25% without making the open offer. Exemption is there under Regulation 3(2). That is, creeping acquisition beyond 5% is allowed, subject to it meet out with certain pre-laid conditions under takeover regulations. So in that company, what happened is that the promoter holding was at 24.95%. And in rights issue, it is like, if public do not subscribe, the onus is on the promoters to subscribe for the additional portion to make the issue successful. So in case the promoter subscribe over and above their entitlement, then there are chances that it might breach 25% limit and has to comply with open offer requirement. So SEBI of late has recognized this particular issue and has granted particularly to that case exemption to that case, and that exemption will be valid on case-to-case basis. But still, that is quite an important exemption, because most of the rights issue were failed at the inception stage only by the promoters due to the fear of giving an open offer, because it was very clear that those exemptions were not given earlier. So if SEBI is considering these situations and problems which promoters and companies are facing in raising funds, so that is quite a good indication for the capital market, and we hope that many more rights issue fundraising activities will be done. So that is all from my side. Thank you.
Thank you, Neeti, for taking us through the updates in the various SEBI circulars, and particularly taking us through the exemption which may be available on case-to-case basis in rights issue. That is very important in my mind, and very useful information you have shared with us. May I now invite Shri G.P. Madanji to take us through some updates in insolvency law. Over to you, sir. Please unmute, sir.
Am I audible, sir?
Yes, yes, sir.
I'm actually logged in with two devices because I'm not in Delhi. So there is some internet issue. So I've logged in from two devices. One I'm using for audio and other is for video. Thank you, Agarwal sir, for giving me this opportunity to be one of the panelists under your aegis, one of the thorough professionals, and I'm really privileged to be here. Sir, with respect to this Insolvency and Bankruptcy Code 2016, there has not been any latest modification, but there have been number of case studies which actually force the government to make amendments in the law. And two or three case studies I'll be discussing. Plus, there are certain indications from the government to make further changes in Insolvency and Bankruptcy Code. One of the changes, one of the latest case studies with respect to real estate company Earth Infrastructures Limited. The judgment was pronounced by, the matter went to appellate tribunal and appellate tribunal pronounced a detailed judgment. And the facts of the case, though I'm not having a PPT, so you need to hear me carefully to understand the facts of the case. And if you hear the facts of the case carefully, then only you'll be able to understand what is the final verdict. What has happened in this case? There is a holding company. Because all of you are professionals, understand this relationship very well. There is a holding company, Earth Infrastructure Limited. This company applies to Greater Noida Authority for allotment of land. Actually, at that point of time, this Earth Infrastructure Limited applied for allotment of land in consortium. And a plot of land is allotted to this consortium. But one of the conditions of allotment was that this consortium shall incorporate a company. Sir, I'm not visible now, I think. Am I?
You are visible. Invisible.
Okay. One of the conditions, just a minute, there's some problem at my end. Am I properly audible, sir?
I think there's some audio problem.
Just a minute, sir. Let me leave this. Am I audible now properly?
Yes, yes.
Okay. So one of the conditions of the allotment was that this consortium shall incorporate a SPV. And the lease deed shall be entered into by Greater Noida in favor of SPV and not in favor of consortium. So this consortium followed the instructions and constituted a SPV, which is 100% subsidiary company of this holding company. Now what happens? With this consortium, the lease deed is executed. Now similarly, there are 4 other subsidiary companies and 4 other different projects. So now the situation is there is one holding company and 5 wholly owned subsidiary companies, and all 5 subsidiary companies are having one project each. Out of this 5 projects, 3 are in Greater Noida and 2 are in Haryana. So for both of them, for these 5 projects, there are 2 different land regulators. One Greater Noida, and for 2 there is DTCP, Chandigarh. Now what happens? these 5 companies enter into separate development agreement with the holding company. And then these companies come out with their projects. And the home buyers can give money either to the holding company or to the subsidiary company, and the allotment shall be done. Allotment money is paid by the allottees, allotment is being done, allotment is done. Later on, what happens? This holding company becomes defaulter. Actually, the land owning company, the 5 subsidiary companies, they become defaulter. The holding company files bank insolvency petition. Not holding company, some of the actually buyers, they file insolvency petition against the holding company, that is the parent company, Earth Infrastructure Limited, and the petition is admitted and CIRP commences. The one CIRP commences, now there have to be resolution plans. 2 resolution plans come. One for first 3 companies. Let me say that they are company A, B, C, D, and E. Subsidiary companies. One plan is there for company A, B, and C, and another plan is for company D and E. In company D and E, one project is in first plan A, B, C. That in that consortium, 2 projects are in Greater Noida, and one is in Haryana. So it's a complex situation here. Ultimately, what happens? The allottees of company E, which is in Haryana, they also file an insolvency petition against company E, and that application is also admitted. Now there are a lot of confusions on this. And for that, another resolution plan comes. And that company now gets separated. Now we have company A, B, C, and D. For company A, B, C, we have one plan. For company D, we have another plan. Company D's project is in Greater Noida. Company A, B, C, 2 are in Greater Noida and one is in Chandigarh. Gurgaon, but based and regulator is in Chandigarh. The 2 plans are there. Both the plans are there before adjudicating authority, that is NCLT. Both the plans are approved by adjudicating authority. Now, in both the plans, there is a condition that Greater Noida shall transfer its leasehold rights in favor of the resolution applicants. Now, once the plans are approved, these resolution applicants go to Greater Noida Authority and say that you transfer leasehold rights in our favor. Greater Noida Authority says, sorry, who are you? I don't recognize you. What you have acquired? You have acquired the assets which belong to the subsidiary companies. And subsidiary companies are not into insolvency. What is into insolvency is company, holding company. So these are the assets. This is the land of subsidiary companies. And in the resolution plan of the holding company, the assets of subsidiary companies cannot be used. Assets of the subsidiary companies cannot be part of the resolution plan of holding company. Therefore, we do not recognize you. The resolution applicant go to adjudicating authority again and file an application that this land should be transferred to us. Adjudicating authority again passes an order and directs Greater Noida Authority to transfer the leasehold rights. At this stage, Greater Noida Authority again says no, sorry. Now the resolution applicant, they file a contempt application. And once they file contempt application, now Greater Noida Authority approaches appellate authority and files an appeal against the notice against contempt, as well as appeal against the original plan approval orders. Now the matter is before appellate authority. Appellate authority very clearly says that assets of subsidiary companies cannot become part of the resolution plan of holding company. This stage, and was very well aware that what is happening in this company, in the holding company. They never objected to that. And actually, Greater Noida, in some of the companies, for some of the land they filed the claim, for some of the land they did not file the claim. But ultimately, appellate authority decides that these lands belong to the subsidiary companies. Subsidiary company assets cannot become part of the assets, cannot become part of the resolution plan of the holding company. Therefore, the resolution plan approval orders of adjudicating authority are set aside. Now at this stage, CIRP will commence again. 6 months period is granted. In the meantime now, within 15 days from this date, from the date of his judgment, Greater Noida shall communicate its dues to the RP of the holding company. Now at this stage, once these dues are received, intimation is received, RP shall publish fresh Form G and will disclose all these facts in Form G so that the prospective resolution applicants know each and everything. And whenever there is a resolution plan, the resolution plan shall be first sent to Greater Noida Authority for approval. And if they approve it, then it will come to the Committee of Creditors. And then if Committee of Creditors approve it, then the plan shall be submitted to Adjudicating Authority for approval. According to me, all this is non-starter. This cannot happen because nobody will be ready to pay the dues of the Greater Noida Authority. And if the dues are not paid, if there is a resolution plan which provides say 10 to 25% or 10 to 20% of the dues of the Greater Noida Authority, the authority will never approve such a resolution plan. So that this company, this project will remain in limbo for all times to come. And that actually happened. Now at this stage, Greater Noida Authority submit its claim for one of the units only for 200 crores of rupees. And everybody is sure that no resolution plan will be for more than 200 crores of rupees. And unfortunately, what has happened? The plan ABC, C land is in Haryana, nothing to do with Greater Noida. And resolution plan was one only, ABC for ABC. That resolution plan approved by adjudicating authority earlier now stands set aside. There is no resolution plan of the company C also, for which Greater Noida is not a regulator. But all the plans have been set aside. Now what happens at this stage? All the parties, the resolution applicants, the resolution professional, the residents, the buyers association, all of them have filed their respective appeals in Supreme Court. In the second hearing, Supreme Court has issued an order of status quo. The matter is lingering before the Supreme Court. And I don't think before next 6 to 9 months, this issue shall be decided. Now, in the meantime, the buyers, the allottees do not know what is going to happen in this case. Whether they'll be actually allowed, they'll be getting their flats or not, or whether ultimately this company will go into liquidation if there is no resolution plan. We need to wait for the verdict, but this particular judgment, according to me, is against the interest of the allottees. And allottees are the sufferer. The value of the assets of this corporate debtor is getting deteriorated day by day. This is one of the judgments. Another judgment, friends, all of you have gone through that judgment last year, that was Rainbow Papers, where it was decided that the Gujarat VAT Authority is a secured creditor and should be dealt at pari passu with other secured creditors in the resolution plan. What has happened after that? The after effects of that judgment of Honorable Supreme Court. Actually, at one place in the judgment, it is said that if the dues of statutory authorities, legal authorities, or other authorities are not made part of the resolution plan, then that resolution plan cannot be approved by the adjudicating authority and company will have to go into liquidation. Now, suppose if the dues of all these authorities are to be provided in the resolution plan, then certainly the committee of creditors will not approve such a resolution plan. Committee of creditors, which comprises of primarily the banks, the secured lenders, they will always prefer, let's take action under SARFAESI rather than going into insolvency and bankruptcy code. The after effect which I was talking about is that after that judgment, in all other pending cases, various statutory authorities or bodies have come forward and now they're filing their claims, claiming themselves to be as secured creditor, leaving a room for the COC members not to approve the plan. And if that happens, ultimately all this company will go into liquidation, which is against the spirit of the code, against the preamble of the code. The preamble of the code talks about only rehabilitation, revival, restructuring. It does not talk about liquidation at all. But if such an action happens, and the COC will have no other option but to reject the plan, such a plan, certainly those companies will go into liquidation. Even one of the cases, surprisingly, the appellate authority has said that even the income tax dues are secured debts, and income tax authority is secured creditor. While if you see section 53 of the code, which talks about the waterfall mechanism, there it is very categorically said that government dues are almost at the bottom. And preamble of the code also talks about that there is recategorization of the government dues, reclassification of government dues. Government dues are almost at the bottom and government is not going to get anything. But because of the judgment, government has come on top. And that's really surprising that actually the Ministry of Corporate Affairs has now decided to bring amendments to the code and bring clarity on this. But that amendment will take another 3 to 4 months because that amendment will be proposed, according to me, in the next monsoon session. But in the meantime, all the pending resolution plans, they are in limbo. Because adjudicating authority cannot approve such plans. Adjudicating authority is bound by the decision of the Honorable Apex Court. The third issue which has arisen nowadays is the provident fund dues. Honorable Supreme Court has said in a couple of cases, particularly Jet Airways and Mozarbear, that if there are employees' dues, they have to be paid in priority in the resolution plan. And employees' dues does not mean employer contribution or employee contribution. It also includes interest, penal interest, the damages, everything. Whatever the claim is being made by the Provident Fund Authority, that those claims have to be discharged in priority. Now think of a case where suppose the liquidation value is 10 crores and the resolution plan is of 12 crores. COC approves the plan. Now once the plan is approved, after that EPFO filing a claim of 15 crores. It means entire amount of 12 crores will go to EPFO and bankers will not get even a single penny. If that is the issue, then why should the bankers approve such a plan where there will be a sword hanging on their heads and there is a possibility they may not get even a single penny. Therefore, nowadays, what has happened, very less number of applications are being preferred by the banks under insolvency and bankruptcy code. वो बोलते हैं हम corporate debt restructuring कर लेंगे, one time settlement कर लेंगे, we'll invoke SARFAESI, but we will not file an application under say IBC. So I'm sure that even the government may think of bringing clarity on this issue also, maybe in the monsoon session. But till that time, the success of the IBC, there is a question mark. Further, friends, last week only, I think, 3-4 days before, you must have seen a newspaper communication, maybe press release, that government is thinking of bringing certain changes in the IBC now, particularly with respect to the delays which are being caused, and the public at large is accusing the adjudicating authority for all these delays. कि NCLT में application जाती है, कोई decision नहीं होता है. But nobody looks at the fact that NCLT is not having infrastructure. Against the sanction strength of 63 members, we are having only 36 members. And 63 members were also sanctioned at that point of time when NCLT was there under the Companies Act for Companies Act. IBC came later on, and IBC designated NCLT as adjudicating authority under IBC. So all the Companies Act matter on the back burner. IBC has become a priority. Strength is not there. Space is not there. Now the government has decided that we need to increase the strength. We need to provide infrastructure, and we need to have use of artificial intelligence also. This is a very, very welcome move. And another thing which the government is proposing now, that if any frivolous application is filed in NCLT to derail the resolution plan or implementation of the resolution plan, then for all those frivolous applications, heavy penalties shall be imposed by adjudicating authority. Friends, there is a lot to say on this, but the time constraints are also there. I'll discuss with you one more incident. I'm not saying case study, but incident. And all of you must be eagerly waiting for the verdict of Honorable Adjudicating Authority in Go First. All of you know that Go Air case was filed by Go Air under Section 10 of the Code, where a corporate debtor can file an application for its own insolvency. That matter was mentioned day before yesterday before the principal bench, and matter was listed yesterday as item number 1. The arguments on the matter went for 4 hours. And fortunately and incidentally, I was very much present in the courtroom yesterday. Actually, primary prayer is admission of the application under Section 10. But as you know, admission cannot happen in one hearing because principles of natural justice have to be followed. So the day admission happens, the moratorium kicks in under Section 14 of the Code. But till the time the admission order is there, moratorium cannot be there. But this petitioner, the corporate debtor, Go Air, says we need interim protection. We need interim moratorium till the time the application is finally decided. The other party says there is no provision of interim protection under the code. No interim moratorium can be granted. Even the bench was also of the view that interim moratorium cannot be granted because there is no provision in the code. Again, incidentally and fortunately, I was present in the courtroom. And in the history of IBC, in my own case, where I was a counsel, interim protection was granted sometime in the month of June 2017 by Chandigarh bench of NCLT. So I just discussed that matter with the counsel of the petitioner during lunchtime, and later on they quoted that judgment, that particular order. There is one case, adjudicating authority has always granted interim protection, has already given interim moratorium till the finalization of the application, till the consideration of the application. So after 4 hours of hearing, the order has been reserved, whether interim protection can be given or not, whether interim moratorium under Section 14 can be granted or not, because the plea of the applicant is, if interim protection is not granted, in the meantime, everybody is talking about refunding of the money and cancellation of all the contracts. Out of 54 aircrafts, we are having only 26 are already grounded. 28 are there in the air. Now, if interim protection is not granted, my banks will be frozen. The lessors of these 28 plans will also ask for the return of the aircrafts, and the company will close down. So our intention is to run the company, to keep the company as a going concern. Therefore, we request the interim protection is granted so that no further coercive action is taken against the company. And in the meantime, the company tries to get its operations revived. And actually, for those 24 planes which are grounded, the plea of the petitioner is that the engines which were supplied to the company were defective. However, in the meantime, there has been some arbitration award. Award is in favor of the company, and there is a possibility that these engines shall be replaced very soon. Once these engines are replaced, then certainly all 54 aircrafts will be in the air and the company will be able to survive. The second reason which has been given by the pet company is that for the coming season, May and June and July, the lakhs of passengers have already booked through Goa. They have planned their holidays. If the company is not allowed to function, then certainly this flight shall be cancelled and their programs will also be cancelled. So this will be causing trouble to those passengers, the tourists. And thirdly, last but not the least, there are direct and indirect employment of 17,000 employees. If this company closes, the 17,000 employees will come on road, because all of us have seen the consequences of closure of Kingfisher as well as Jet Airways. In those two companies also, those companies never revived, could not revive. So therefore, the company pleaded for an interim protection. Order has been reserved, and I'm sure, I wish order is in favor of this corporate debtor, the applicant under Section 10, and the company is allowed to run its functions. Thank you very much, Agarwal Sahab, for providing me the opportunity, and I'll be happy to take any questions.
Thank you, Madanji, for taking us through these beautiful three cases. And just to share with the audience that IBBI has come out with a discussion paper. In fact, it's not a discussion paper. They invited suggestions for changes in regulations. It's an open paper, and almost any regulation made by IBBI, suggestions can be given, and they have kept the open window quite open, and a lot of time has been given.
Till 31st December 2023.
Yes.
And my request to you, Agarwal Sahab, if we can have a series of webinars on that, maybe a series of closed room discussions to discuss all the regulations, so that we from corporate professional also give our suggestions to IBBI. That will be great service to the stakeholders.
We'll take your suggestion. Thank you very much, Madanji. We'll certainly go ahead with that. Now, thank you, sir. Thank you, Madanji.
Obliged, sir.
Now, may I invite our brilliant advocate, young advocate, Mr. Ravi, to take us through some of the latest decided cases. Over to you, Ravi, please.
Thank you so much, sir. And I express my regard for the panelists who have spoken before me, especially Madan sir, who eloquently embarked on the developments on the IBC front, the nuances, and also the developments that are going to decide fate of so many companies, and as well as the economic resources. Now, I'm restricting myself to the realm of securities law, where there have been some couple of developments, particularly pertaining to the substantial acquisition of shares and takeovers regulations, commonly known as takeover regulations. The first case I take is of Anil Kumar Poddar, which name must be resonating with a lot of listed companies and the people who are working in listed companies and who are attending this webinar. And this appeal was decided on 11th of April 2023. The question was whether a whole-time member of SEBI can exercise discretion when the allegation is that a person has breached or triggered the thresholds contained under takeover regulations. The facts of the case were that a group of persons triggered Regulation 3, Sub-Regulation 2 of takeover regulations that talks about creeping acquisition, that when you acquire more than 5% in a financial year of a target company, of a listed company. And the natural consequence provided in the law for such a trigger is that the acquirer has to come out with an open offer. In this case, the persons had acquired more than 5%, and on an investigation conducted by SEBI, the whole-time member did not order for bringing an open offer and rather exercised the discretion contained under Regulation 32 of the Takeover Regulations, stating that since the case is peculiar and there were several disputed questions of facts regarding the transaction which led to the increase of more than 5%, and as those questions were pending before various authorities, therefore it would not be proper for SEBI to treat it as the ordinary case of a trigger, open offer trigger, in order for bringing an open offer. Against that order of whole-time member, this appeal was preferred. And the short point that fall before the tribunal to decide is whether whole-time member in its discretion can pass such an order when there are judicial precedents from SAT as well as from higher courts that the first measure in case of open offer breaches is that you should order for bringing an open offer. Now, here comes the interesting part in development. Recently, on 11th of July 2022, in case of SEBI versus Sunil Krishna Khaitan, which case, Agarwal sir, you only forwarded to me for further reading. In that case, the Supreme Court interpreted, and it juxtaposed that Regulation 32 is not a new set of regulation. It is not a new concept under the Takeover 2011 regulations. Rather, it is the corresponding provision to the Regulation 44. And because the provision itself is discretionary, as it uses the word may, it is not mandatory for the whole-time member of SEBI to follow the sequence of clauses as if it is a distribution waterfall, that you have to go in accordance with the clauses written down, and the discretion can be exercised. Ultimately, SAT observed that since the whole-time member has recorded reasons in the order for not interfering or for not ordering to come out with an open offer, SAT said we would not ordinarily be induced to interfere with a discretion which is backed by reasons. And therefore, they declined to interfere and the appeal was dismissed. Now, it is another matter whether it was out of the scope of SEBI to examine thoroughly whether those questions are really disputed questions or those have been made up as a defense to thwart and direction of giving an open offer. Secondly, the broader consequence of such order and it being upheld by the Securities Appellate Tribunal is that whether such kind of structuring can be done by people going forward to avoid open offer obligations. Now, the second one is in case of Asit C. Mehta Investment Intermediaries Limited versus Securities and Exchange Board of India. The decision was again rendered on 11th of April. And this is rather very important for the intermediaries, particularly for the brokers who are operating in the market. This broker was registered as a member with both NSE and BSE. And both the exchanges found this broker to have violated certain provisions with respect to misuse of client funds, short collection of margins, client funding, client registration process, and various other requirements pertaining to KYC, incorrect reporting. And both the exchanges had levied penalty on the broker in accordance with the bylaws. Later on, SEBI initiated an adjudicatory proceedings against the broker on the same set of violations and imposed some penalty. Apart from that, there were some independent observations under SCRA, which is the Securities Contract Regulation Act that applies on broker as well. And SEBI imposed penalty for that violation. So far as the penalty imposed by the adjudicating officer, and this is, I'm quoting from SAT's judgment in simple words. So far as the penalty pertained to the same subject matters for which penalty was already imposed by the exchanges on the broker, SAT said it tantamounts to double jeopardy, and therefore they said this can't be allowed in the welfare state, in a state which follows the rule of law, and therefore they quashed the penalty while the other penalties were upheld. So we have found application of Article 20 Clause 2 of Indian Constitution by Securities Appellate Tribunal in deciding whether a penalty could amount to double jeopardy. Although I must point out in all fairness that when this ground was taken in earlier appeals by people, there are judgments from SAT and various other courts which say that Article 20 and particularly the clause 2 of that article, it applies in respect of proceedings which can lead to punishment. And because penalty is different than punishment, a monetary fine or penalty is different than punishment, therefore this article has no application. So that this order of SAT needs to be tested on that aspect. The third one is in the case of fast money is another matter, and it was rendered on 10th of April 2023 by SAT. The issue was much simpler here. Someone was found to have been running unregistered investment advisory by SEBI, and the person appealed in SAT. SAT categorically observed that based on the material on record, it is established that the person was running the investment advisory business without registration. Although there were no remarks of any defalsification of funds or siphoning or cheating the investors. Therefore, SAT observed that the imposition of 15 lakhs as penalty by SEBI without recording any reason for imposing such excessive amount of penalty on this intermediary merely because of non-registration seems to be excessively harsh. So therefore, the penalty was reduced applying the principle of proportionality, and the order was not interfered in its substantive portions so far as the findings were concerned. The next case is, and this is seminally important for listed companies and those who are, and the professionals who deal with compliances pertaining to LODR and listed companies. Now, this case, the decision in this case is rendered on 11th of April 2023 because this is very important and directly relevant for many company secretaries and compliance officers. I quote the appeal number 597 of 2022, rendered on 11th of April 2023. In the matter of Shri Pushkar Chemicals and Fertilizers Limited versus National Stock Exchange of India Limited and BSE Limited. What happened in this matter is that there was a delay in appointment of women director as per Regulation 17 of LODR regulations, for which NSE and BSE both levied some penalties on the company. The company took a defense before the exchanges seeking waiver of fines. And because this period of default was for 2020, June quarter and September quarter, the company took a defense that because of the lockdown and black swan event of COVID, they could not appoint a woman director as the entire life, not only economic activities were at standstill. The defense was rejected by both the stock exchanges and penalty was upheld. However, SAT has decided the matter, taking the COVID as a ground, as a justifiable ground, and set aside the penalty, said that the order can't sustain because you can't sleep. I mean, in other words, the exchanges have to be alive to the situation that prevailed during that time, and penalties can't be levied mechanically. And they also refer to decisions rendered in Sekhavati Polyyarn Limited, that is appeal number 432 of 2021 for the benefit of listeners, rendered on 18th July 2022, and Kesar Petro Products, which is often quoted by professionals who are arguing in SAT for the similar matters. So finally, SAT has recognized COVID as a reasonable ground to not follow the compliances, but especially pertaining to the appointment of directors on the board, and so far as the board constitution is concerned. The next case is of Subhash Agrawal versus SEBI, again very important for the compliance officers and the fraternity of company secretaries, as well as the directors on the board of listed companies and the listed companies itself. This was also rendered on 11th of April 2023, seems to be a momentous date for listed companies. Here, SAT again was examining the the significance of LODR violations. And in this case, SEBI had conducted an investigation. Investigation did not bring about any kind of siphoning of funds or misappropriation of funds, any kind of FUTP, fraud and manipulation violations. The only violations were pertaining to listing obligations and disclosures requirements regulations, LODR. And a hefty penalty was imposed, as well as banning was also done for 1 year and for 6 months, respectively. In case of few people, it was for 6 months, and in some, it was for 1 year, apart from the penalties that were imposed jointly and severally, and also individually on people. SAT observed that ordinarily, the violations of LODR won't attract harsh penalties, and one need to see whether the violations are technical or these are of the substantive provisions which affect the interest of other stakeholders. And in case of violations which do not yield into any disproportionate gain, nor yield into any unfair advantage, nor any specific loss was created to any investors, hence the debarment and penalty was excessive, and they rationalized it. They said that the debarment would get over and the period undergone is the period of debarment, and the penalties were substantially reduced. Now, another one, it is on 27th of April 2023, again from SAT. And the appeal number is 185 of 2023, very recent matter. It is in the matter of Nectar Life Sciences Limited. The issue here, in summary, was that whether Regulation 17(1)A of LODR, which says that you can't appoint a person as director who has surpassed the age of 75 years unless special resolution is passed. So therefore, this word unless was interpreted by SAT. It has been interpreted by SAT whether the appointment of director, what is the scheme for appointment of directors by the shareholders and by the board, and what is the concept of casual vacancy. To summarize the controversy that arose in this matter is that a company was facing a situation of casual vacancy because the earlier appointed director passed away, and in place of that director, they appointed a retired general, retired army officer who had surpassed the age of 75 years. So therefore, the exchange said that this is not the proper compliance with 17(1)A because you could have not appointed this person without approval of shareholders. SAT has determined that there is no provision, and I quote from SAT order, that there is no provision in LODR regulations for filling up a casual vacancy of a director in the company. And then they say Regulation 17(1)A should be read harmoniously with the provisions of Section 152, Section 161, subsection 4 of the Companies Act, read with Rule 4 of the rules, and Regulation 17(1)C of the LODR regulation, which makes it clear that even if a person above the age of 75 years is appointed by the board of directors to fill up a casual vacancy, such appointment is required to be approved subsequently within the prescribed period by a special resolution in the next general meeting by the members of the company. And merely because no prior approval has been taken, it does not lead to automatic violation of the provisions of LODR. The SAT did not stop here. Said the word unless depicted in Regulation 17(1)A does not mean prior approval, nor the requirement of passing a special resolution is a qualificatory condition for appointment of a person as a director. On these counts, they set aside the penalty imposed by exchanges and allowed the appeal. Now, this is all because I have I think the time has shot up, so I would just quote one judgment from Supreme Court, which is rendered on 2nd of May, 3 days ago. And this is very seminal for the practicing professionals, as well as who have to deal with the matters of law and quote precedents and evaluate the precedential value of any judgment or any issue which has fallen from the courts. The cases of CIES versus Sri Thakurji Educational Society The case was concerning the case of Vidya Drolia versus Durga Trading Company, which was rendered earlier by Supreme Court, in which they had talked about the concepts of quasi-partnership. And a company is a company, howsoever small it is. And it touched upon some aspects of arbitration also. And the challenge was that someone was relying on Vidya Drolia as a precedent in cases of unstamped arbitration agreement. The court said, no, that's not what the Vidya Drolia case talks about. And then court did not stop there. Usually, Supreme Court dismisses a misreliance on a precedent in Supreme Court results into a terse order, which says that we do not find any merit and hence there is no interference, appeal is dismissed. But here, Supreme Court thought to educate the fraternity by laying down what is the principle, how you should shaft the grain, how you should separate the shaft from the grain, and how you should identify what is the binding precedent, what is the ratio decidendi of a judgment from an obiter dictum. And the court said, not everything said in a judgment constitutes a precedent. You must be able to distinguish between an obiter dicta and ratio decidendi. And one of the tests that the court has propounded is called the inversion test. What this test means, let's see. Whether a particular proposition of law is to be treated as the ratio decidendi, the proposition is to be inverted, which means that you remove the proposition from the text of the judgment as if it does not exist, and then you see if the conclusion arrived by the judges or in the judgment is the same by taking away that part. It means that the principle has no application to reach to the conclusion, and therefore it is not a ratio decidendi. And then they said that it is not the findings of material facts, direct and inferential, but the statements of principles of law applicable to the legal problems disclosed by the facts, which is the vital element in the decision and operates as a precedent. Even the conclusion does not operate as a precedent, albeit it operates as res judicata. Thus, it is not everything said by a judge when giving judgment that constitutes a precedent. The only thing in judge's decision binding as a legal precedent is the principle upon which the case is decided. And for this reason, it is important to analyze a decision and isolate it from the obiter dicta. So that is all from my side, sir. It is the principle of law on which the case rests, on which the facts exude, and which the court considers to lay down the conclusion. That is the binding precedent, and not everything under the sun which is captured in the judgment. That's all, sir. Thank you so much.
Thank you very much. Thank you very much, Ravi, for taking us through these very important judgments. Particularly, I enjoyed the last judgment. Friends, we've already overshot. Quickly, Devashri, are you there? Can I ask you a question?
Yes, sir.
Yeah. What will be the impact of the new master direction on the existing IT outsourcing agreements?
So the existing agreements, the impact will be determined basis the date on which the agreements are due for renewal. In case the agreements are due for renewal before 1st of October 2023, which is the date of implementation of the master directions. In that case, it is advisable that the changes are incorporated immediately or latest by 12 months from the date of issue of these directions, which would be 10th of April 2024. So it is advisable to have it implemented immediately or latest by 10th April 2024 for the agreements which are due for renewal on or after 1st of October 2023. In that case, it is advisable to, of course, have the changes incorporated immediately or latest by 3 years from the date of issue of these master directions, which would be 10th April 2026, whichever is earlier. And for new agreements, again, basis, this was, I know the question was for the existing agreements, but for new agreements, the same principle will be followed basis the effective date of the agreement. This is it.
Thank you, Devashri. I have a few more questions, but they are not arising out of the discussions which took place today or out of the regulatory updates. So we will reply them separately. Before I conclude, I must thank all the very learned panelists for sparing their valuable time and sharing their insights into the various intricate subjects and the updates. We've all benefited quite a lot from this. And